फुल स्क्रीन कर ले फुल स्क्रीन था ना पहले फुल स्क्रीन बैकग्राउंड में है क्या उछाल ठीक है ना
Welcome back, delegates. Our fourth talk will be given by Dr. Dilip Walke on end-of-life decisions in critical care. Dr. Dilip Walke is an MBBS and an MS of Obstetrics and Gynecology, consultant in Jupiter Hospital, Baner, and Vitalife Marypoint Hospital in Aundh, Pune, Chairman, Ethics and Medical Legal Committee of the Federation of Obstetrics and Gynecological Societies of India, 2007-2010, President of the Pune Obstetrics and Gynae Society 2019 to 20, and mentor and founder of Pune IVF. He is also on the advisory board member of Dr. Prax Telemedicine Solutions. We welcome you, sir.
डायरेक्ट काहीच नाही केलं मी मिनिमाइज केलं फक्त झूम बंद झालं वो नहीं है मैंने इसे ट्रांसपोर्टिंग करने की जरूरत नहीं है ना
just like technology enabler, sometimes it also sometimes complicates life.
अभी होगा ना? Sure. Okay. अभी वो स्लाइड आगे नहीं जा रही. Okay. Now, since all these legal luminaries that I call them, the fact that I know them and the fact that I'm friends with some of them make me look like a medico-legal expert. Actually, I'm not. I'm just a simple clinician, and only because I interact with these legal luminaries, I'm seen as a medico-legal expert. So, what the secret of my talk is, what I do is I listen to them. I nag them till I decode all the legal jargon that these people use, and I use it in my talk in a very simple language, and to which I add my legal tadka of abundant clinical caution, and I add a little more tadka of some of the jugards that we can do in our clinical practice. And that's how my talks become. That is the secret of my talk whenever I speak on medical legal aspects. And you know what? Whenever I come here, I speak with a lot of confidence. The reason is I know that the problem with the world is that intelligent people are full of doubts, while the stupid ones are full of fun. So for the next maybe half an hour, this is my stupidity. This is the agenda of my stupidity with you for the next half an hour. First of all, let's try to understand what is end-of-life care in terms of its definition, in terms of the load that is there worldwide, and in terms of what is exactly the DNR concept. Now, some definitions that we are going to use for the purpose of this talks are, what is an end-of-life care? End-of-life care is care of a terminally ill patient till we can give good death to that patient. This is what is end-of-life care. Euthanasia, two types, either a passive euthanasia or an active euthanasia, but basically euthanasia is a good Greek word for good death. So it can be active euthanasia, where you can deliberately give something to kill the patient, or passive, where you withdraw something so that the patient dies. What is do not resuscitate? Do not resuscitate means treatment decisions taken prior to the cardiac arrest with the consent of the patient or the proxy of the patient to refrain from providing cardiorespiratory resuscitation while we continue to do certain things. So this is what is the legal definition of DNR. And unfortunately in our country, death is not yet defined. Only death is defined in terms of brain death, only that too in the Organ Transplant Act. So that is the most unfortunate part. The load of end-of-life care patients worldwide has been captured in the Global Atlas of Palliative Care of 2014, which was prepared by the WHO and the WPCA, wherein they say there are 20.4 million patients of end-of-life care globally every year, out of which 98% are elderly, 79 up to 98% are basically middle income and low income. And the most common causes are cardiovascular disease, cancer, or chronic respiratory disease, and HIV and diabetes. Situation in India, I do not have the exact figures of the end-of-life care patients in India, but there was a study that was performed by the Cipla Palliative Care, and they say in India there is no social security, and that is because of that there is financial burden on the relatives. Because there is financial burden on the relatives, there is a high incidence of DAMA, that is discharge against medical advice, and because there is lack of legal protection to the doctor resort to defensive practice and unethical jugards, as I call them. And because of lack of care at home, there is a lot of suffering. And that's the reason why I sometimes feel whether end-of-life care is holistic care or holistic suffering. That is something that I ask myself. Now, a little look at the DNR concept, the ethical consideration. Ethically, DNR should be guided by the principles of autonomy, beneficence, that is the best interest of the patient, and non-maleficence, no harm. The intention of DNR should be to kill the pain and suffering, and not to kill the patient or not to hasten the death of the patient. So this is what not only you should do it, but you should be seen to be doing it. You shouldn't be seen to be killing the patient. You should be seen to be killing the pain and suffering of the patient. And it is about giving a dignified death. This is what is a DNR. Ethically, doctors opt for DNR in following situation. Either the life-sustaining treatment is likely to be futile, or it is likely to bring an undignified death, or it is likely to cause misery to all concerned, or it can be when there is a brain death like situation, or it can be for a condition where there is no treatment available. And we consider some indications, but we do not talk about them. We are very quiet about those indications. And these are financial and physical or psychological burden for the relatives, society or healthcare providers. Meaning, paisa khatam ho gaya. Ab kya karne ka? Life support band kar dalo. Or presence of another salvageable patient deserving the care because it is more likely to have better outcome. Like in an NICU, if there is a premature and little less premature, you will tend to give care to the one who is a little more mature than the one which is more premature. These are some of the unethical reasons for which we may do DNR. And sometimes doctors at times have to withhold DNR, even if the patient is deserving to be given DNR, in cases like where the relatives are not available, or the relatives are available but are not giving consent, or relatives available but there is conflicting opinion about in between the different relatives, or if you are in a situation where there can be a may or may not improve kind of a situation. So that is the time when doctors would not want to give DNR even if the patient is deserving. Two types of DNRs, everybody knows that. Either it can be withholding the life-sustaining treatment, and sometimes they call it do not escalate also. They call it DNE, wherein what you are doing is you are refraining from putting on ventilator, or you are refraining on putting on a central line or a replacement therapy. So this is withholding, the treatment that could be beneficial for the patient, or withdrawing the life support treatment, like withdrawing ventilation, withdrawing the inotrope support. And this is the crux of the discussion today, and that is what is called as passive euthanasia. What can we commit to do and omit to do ethically in DNR? One is we can commit to do chest compression. We can omit to do in DNR chest compression. We can omit to do intubation. We can omit to do ventilatory support. We can omit cardiac resuscitation drug, and we can omit defibrillation. But even when you are omitting to do all these things in your DNR, we cannot omit to do things like clearing airway, providing oxygen, giving position for comfort of the patient, controlling bleeding if it is there, providing pain medication. So just because you're doing DNR does not mean you're not supposed to do all these things on ethical point of view. So having understood what DNR actually is from the ethical point of view, let us now try to find out the challenges faced by doctors and administrators, the ethical dilemmas and the legal dilemmas. Instead of going into just the theoretical discussion of the dilemmas, I thought I'll take clinical situations. So let's have a look at the situation number one, wherein here is a terminally ill, example, a cancer patient needing intubation, needing central line, or needing ventilation, and the relatives come and say, "Hum aur nahi afford kar sakte." Now the relatives are just not ready to pay anymore, but the patient needs ventilation, the patient needs intubation, the patient needs a central line. Now the legal dilemma here is, do relatives have any locus standi to refuse escalation? That's my point number one. My point number two, what if the courts consider these escalations as life-saving measures? Now, this is going to be something which is a life-saving, and the Clinical Establishment Act and the Paramananda Katara case tells us that anything that is life-saving, we are legally bound to do. So what if courts consider that? And what is the legal definition of life-saving treatment? That also we need to understand. And the last thing is, if we do escalate in private hospitals, madam, bill kaun bharega is the question. So these are the legal dilemmas which the doctor is facing and the administrator is facing. Situation number two, similar terminally ill patient is conscious at this moment of time, and the patient is ready to give a DNR consent. Now, such an undertaking in a hospital status, again, will court treat this as a living will? Will court agree that there was no pressure or coercion in the hospital setting where the patient was? And can a magistrate be brought in the hospital to record this DNR consent that the patient is giving? So this is situation number two. Or situation number three is a brain dead patient on inotropes and on ventilator. Now there can be two possibilities, wherein the relatives are willing for organ donation, or possibility number two, relatives are not willing for organ donation. Now, if the relatives are willing for organ donation, no problem at all, because we know these two sections. One section which defines brain death, all functions of the brain stem having permanently and irreversibly be damaged, And we know that it can be certified, and we know once it is certified, then we can withdraw the life sustaining treatment after the organ retrieval, and then the needful can be done. But this HOTA, the Organ Donor Transplant Act, is not for today's discussion. I'll leave it aside. I want to discuss this situation wherein the relatives are not willing for organ donation. Then again, two possibilities. Relatives are not willing for organ donation, but relatives are ready to give consent for DNR. Now, can you do the needful just because the relatives are giving consent for DNR? If we do the needful, what if the relative becomes hostile later on? Other relatives, supposing one relative gives you a consent for DNR, what if the other relatives are not willing for DNR? So there are two relatives. One is saying kar dalo DNR, and another one is saying mat karo. Or there can be a situation where the relatives are not willing for DNR and not willing to pay anymore. In such a situation, what is the dilemma in front of the hospital administrators and the clinicians? And also the hierarchical issue matter, when there is a variance of opinion amongst the relatives, is not yet finalized by the court. The hierarchical issues is finalized for financial matter, for estate matters. But when it comes to giving DNR consent, that has not been finalized by any of the Supreme Court judgments. So in DNR, who is the legal person to give consent and decide the best interest of the patient? This is the parents, the children, the spouse, the friends. And in case there is a variance of opinion, whose opinion supersedes the opinion of the other person? So that has not been decided by the court. So that also becomes a dilemma. And ऐसे वक्त पे क्या होता है? डॉक्टर मालके क्या करूं? ऐसे फोन आता है. At the moment I get a phone call like this, what I tell them is just a jugaad, right? Because we doctors are ready to do everything in terms of जुगाड़. है ना, हम लोग है ना लीगल बातें देख लेंगे, अपन जुगाड़ करके इस प्रॉब्लम से बाहर निकल जाएंगे. So what are the जुगाड़ that I tell them? Give DAMA discharge. But again, if I give DAMA discharge, what if the relatives deny this DAMA discharge? Relatives बोले नहीं इधर ही रखो, तो क्या? जुगाड़ number 2, shift the patient to government hospital in a cardiac ambulance. Again, the question is, what if the relatives deny? Can I involve police? What will the police help me, cooperate with me to take this patient away to a government hospital? These are the questions that are always there. And just because we are in Pune, there can be a Puneri kind of a jugaad also. A typical Puneri jugaad. And you know that Puneri jugaad is what? Ask the relatives to sign an undertaking to say that we no longer believe in allopathic treatment, and we want to take this patient away for Ayush treatment. यानी आप एथिकली भी करेक्ट हो, आपने किसी ट्रीटमेंट के लिए पेशेंट को भेजा और आपके पास कंसेंट भी है. So you can send this patient away for any kind of a homeopathic treatment or ayurvedic treatment in their own residence. So these are the jugads that we tell the patients. But these jugads will work only if the relatives are in sync with us, which means teri bhi chup, meri bhi chup. Patient gaya. So no longer is this jugaad working if we are not in sync with the relatives. So this is one thing that you have to remember, and every jugaad is medico-legally very risky. But we doctors know हमारे DNA में है वो जुगाड़, हमारे DNA में होता है. MTP after 20 weeks not allowed. एक काम करेंगे, माइजोप्रॉस डाल देंगे, वो आ जाएगी लेबर में, और फिर हम ऐसे दिखाएंगे कि वो MTP नहीं था, पेशेंट केम विद पेन्स, है ना. These are the jugaad that we have been doing always. So हम लोग लीगली अपने लिए सब कुछ ठीक करने के पीछे नहीं रहते, हम लोग क्या रहते हैं, जुगाड़ करके निकल जाने का. That unfortunately is in our DNA. We tend to take the whole burden of the hospital, of the administrators, of the patients, of the relatives on our own head और अपना काम करते हैं. That is the problem with us clinicians. So we have to learn to ask for risk-free solutions for our problem. These can come from legislations and from case laws. But let's have a look at the present day statutes to guide DNR and DNR in such a way that doctors are protected. What is the world view on active euthanasia? The active euthanasia is allowed in Netherlands, in Belgium, in Switzerland. Even supposing आपको अपना active euthanasia करना है, तो all you have to do is go to Switzerland. वो करके देंगे आपको. So the only thing I have to spend to go to Switzerland. So that is allowed only in these countries, but it is not allowed in UK, Spain, Austria, Italy, Germany, France, and also not allowed in our country. So when it comes to active euthanasia, forget it. It's not allowed in our country. What about passive euthanasia? So these are some of the cases of passive euthanasia that you need to know. This is only if you're a student of law, you need to know all these cases. Otherwise, don't even look at this slide because it's a very busy slide. When it comes to understanding those IPCs and those case laws in our country, the one thing that you need to understand is these two IPCs concerning euthanasia. Number one is IPC number 306, which is about abetment of suicide, for which there is 10 years of imprisonment. And when a doctor is assisting for passive euthanasia, he should be protected from this IPC, isn't it? Because otherwise he will be seen as abetting a suicide. So that's number one. Number two is IPC number 309, which is attempt to commit suicide, for which there is 1 year of imprisonment. In the wherein मैं सुसाइड करने की कोशिश कर रहा हूं तो मुझे 1 साल अंदर डाल दें. This is something very एक तो मैं सुसाइड कर रहा हूं बिकॉज मैं टेंशन में हूं, ऊपर से कोर्ट आता है कहता तू और 1 साल अंदर जाके, तो मैं ऑलरेडी डिप्रेशन में हूं और मेरे को 1 साल के लिए अंदर डाल दे. बट द प्रॉब्लम इज दिस वाज एक्चुअली this IPC was very in detail. This IPC was discussed in the Aruna Shanbag case versus the Union of India, and it has considered this to be anachronistic and deserving deletion by the parliament, since the person attempting suicide deserves counseling more than punishment. But if the suicide is to be conducted under psychological stress, this is okay. But the suicide is to be conducted because मेरा जिंदगी का सब कुछ हो गया, बेटी की शादी हो गई, मैंने जितना कमाना था कमा दिया, जो करना था, जो मेरा मिशन ऑफ लाइफ कंप्लीट हो गया, अभी मुझे मरना है. इसके लिए this kind of an suicide is not allowed. So it is not a constitutional right of a person to die, right? So let us study some cases, old case laws from Indian Supreme Court, and let us, as I said, keep the HOTA aside for the purview of today's discussion. These are the old case laws. The first case, Rathinam versus Union of India, the IPC 309, that is the attempt to suicide. In the judgment, it was said it is violative of Article 21, and they said that it is wrong to criminalize attempt to suicide. Then came the Gyan Kaur versus State of Punjab case, where the right to life under Article 21 includes right to life with dignity till death. Death आपका right नहीं है, but death तक आपको अच्छा quality life मिले, that is your right. The IPC 309 is still constitutionally valid according to this judgment. Both active and passive euthanasia in this particular Supreme Court judgment was not allowed. In the next case, just because someone feels that his mission of life is fulfilled, cannot apply for a suicide and die. And there are some cases which do not get media attention because of obvious reason, like this PIL in Rajasthan, two-judge bench said that Santara practice of Jains is unconstitutional. But we can understand the government does not want these kind of cases to be discussed in the media, and that's what it is not getting a proper media attention. Now, these cases dealt with the fundamental right to life and right to die. Then it dealt with whether IPC 309 is violative of the Article 21 and whether passive euthanasia is allowed in our country or not. Then came the landmarks Aruna Shanbag case, which dealt with passive euthanasia for a persistently vegetative patient. And I don't want to go into the details of the case. Everybody knows that she was a staff nurse from KM Hospital, was attacked and sodomized by a sweeper, and she was persistent vegetative for 36 years and was living only on mashed food, which was being provided by the KM staff. And the prayer of her friend Pinky Virani was that the hospital staff should be directed to stop feeding Aruna Shanbag because there was no point in she living as a persistently vegetative person. Now, I don't want to go into the details of the case. I just want to come to the guidelines that was given by the Aruna Shanbag case, which says that if the patient is not capable of consenting, the parents, the spouse, close relatives, next friends, or doctors can decide on euthanasia in the best interest of the patient, reflecting what would have been the wish of the patient. We need a mention about hierarchy of consent here. I mean, the court has just mentioned either parents or spouse or close, but the hierarchy of who can consent also should have been mentioned in this particular judgment. And what we have to do is, if we feel that the patient deserves a DNR, then we have to apply to the High Court, because the High Court acts like a parent. The High Court will act like a parent of the patient. So we have to make an application to the High Court. The High Court will appoint a bench of 2 judges. The bench of 2 judges will appoint a committee of 3 eminent doctors, a neurologist, a physician, a psychiatrist, and there can be a pre-appointed committee. The committee will submit its report to the High Court. Then High Court will give a decision whether to do DNR or not, following the principles of best interests of the patient and the views of the doctors and the near relatives. Now, when this judgment came, all those who were working for end-of-life care patients were happy. Chalo, passive euthanasia in our country is now allowed. But the intensivists were not happy because the option that was given in the Aruna Shanbhag case is very time-consuming. You have to go to the High Court. It's time-consuming. It is costly because you have to, a cost is involved in making a writ in the High Court. Financially and psychologically, it causes a lot of burden on the patient and it gets prolonged. It addresses only passive euthanasia and it does not address the end-of-life care in its entirety. So the savior was, again, the Jugards. And that's the reason why phone calls started coming to Dr. Bharti. So my life was not so good because of this judgment. And then came the judgment of 2018. This is the Common Cause a Registered Society versus Union of India. Again, not going into the detail of the judgment, I will just tell you what was the judgment. Number 1, active euthanasia not allowed in our country. Everybody accepts that and we are happy about it. Passive euthanasia is allowed as per the guidelines of the Aruna Shanbhag case. So which means withdrawal of life-sustaining treatment in patients who are not competent to give consent, follow the Aruna Shanbhag case option. Now, the third thing that was told in his judgment that we can withhold life-sustaining treatment. There is no need to escalate a patient if the patient is adult and conscious and given you a consent. So if the patient is adult and conscious and gives you a consent saying that do not escalate, you can do that. Then additional point, which is very important, is an individual has a right to make an advance medical directive or a living will. This is a constitutional right and requires no legislation. So agar maine living will banaya, then my daughter can very easily do the needful for me. So this was living will, then appeared to be a savior for all stakeholders. Everybody thought living will झंझट खत्म, right? तो सब लोगों ने अगर लिविंग विल बना दिया तो ये प्रॉब्लम अपना एंड ऑफ लाइफ केयर का जो है ना, विड्रॉल ऑफ life sustaining treatment. Here is a report of 23rd of February 2011 where Dr. Lopa Mehta, who's an anatomy, if somebody is from KM Hospital Bombay, they would know Lopa Mehta is our teacher in anatomy. She applied for a living will in the Judicial Magistrate First Class. The Judicial Magistrate First Class refused to give her, sanction her the living will because it says that standard procedure or state or the central government to register a living will is not there. So only there is a judgment, but there is no standard procedure to register your living will. And a survey by Times of India, only 25% are aware of that there is something called as living will. Everybody was aware. So, but in general public, only 25% people are aware. Only 6 of them who are aware have made a living will. How many of you made a living will? Nobody, right? Very few. So that, I mean, for an elderly person like me, it is important. You are too young. But then only 6% of those who know that there is a concept like if a living will have made it. So, but 87% thought that it was necessary for television. My question is for the lawyer friend. Most of the lawyer friends have gone away. And my question is for Rajendra also. I have added a line about my wish on DNR in my own living will, the financial living will that I made. I have added this very line. Okay, in case I am in an end of life care kind of a situation, within 72 hours, you can stop the ventilator and you can stop the iron flow. I have registered in a local registration authority now. उसको मालूम ही नहीं पड़ा, मैंने ये line घुसाड़ दिया, उसको मालूम ही नहीं था, उसने accept कर लिया. So now I have got an official registered document of living will. If I am admitted in Jupiter ICU in an end of life care situation, Dr. Rajendra, will you ask your intensivist to do the needful if my daughter shows you that living will? And my lawyers will have to then tell me will you stand by Dr. Rajendra as the Jupiter? Unfortunately, despite this, it is not allowed. Unless I get a living will registered with the judicial magistrate first class. So मैंने ये काम कर दिया है, लेकिन फिर भी I am very sure that it will not be possible for Rajendra to do the needful for me, even in that situation. So that is the reason why we need to do a little bit of advocacy on this. We have good judgments on passive euthanasia. We have good judgments on advanced medical directives, but no guidelines to follow this. Rajendra will be still jittery to do the needful, because so ultimately what we will do is, so again, तभी वाल्के नहीं रहेगा, तभी और कोई रहेगा, उसको पूछेंगे अभी वाल्के की डॉटर भी बोल रही कर डालो, वाल्के ने ऑलरेडी लिख के रहा है. So what is the demand? Do not resuscitate, stop the ventilator, stop the hypotrope, but don't write on the paper. So this is the jugaad that we usually do. What we need to do is advocacy and activism, and many an advocacy and activism have been done by several associations. The first advocacy was done by the Indian Academy of Neurology and Indian Association of Palliative Care, IAPC. The office bearers met on the 15th of August 2015. They formed ELICIT, which is an end-of-life care task force in India, wherein their aim was dying is inevitable, but good death is not inevitable. That's what they say. For making good death possible, they said that there has to be enabling legislation, there have to be good judgments and a proper medical guidelines. And also the Indian Society for Critical Care went into the Supreme Court and registered a PIL because of the difficulties of registering living will. And the Supreme Court has just given directive that the stakeholders should meet and formulate guidelines. And उन्होंने यहाँ से कॉल अपने पास फेंक दिया, right? So what exactly do we aim with these advocacy? We must know what we want. Only then we can do advocacy. So number one, our expectations from the lawmakers, that is the politicians of our country, is to have a central act for end-of-life care. Wherein the aim of the act should be formation of an end-of-life care committee and simplifying protocols through legislation. And what we demand from our politicians are only three basic things. Number one, validate the advanced medical directives or the living will. Validate that. Form a very good procedure for doing it. Establish process of withdrawing and withholding life-sustaining treatment so as to protect all the stakeholders legally also and ethically also, and define death. That they have not done yet. Only the Kerala government has defined procedure for brain death declaration in a non-organ donation. Only Kerala government has done it. No other government has done it. And these three things do not require any budget. All that is required is our lobbying with these politicians. So this is what we expect from the politicians. Our expectation from the judiciary is to make the guidelines of Aruna Shanbhag case a little easy to implement. Can they say not good? There's no need to go to a high court, go to a smaller court instead? Can there be a fast track procedure, say something which can get over within 5 to 10 hours? I mean, when we take a decision, we have to do the needful within 5 hours, isn't it? Can there be a procedure which is fast track, or can there be an easy online procedure for making an application to the High Court and doing it online? And there has to be practical solutions for registering our living will also. And our expectation from the civil society is to create awareness of living will and join hands with activists for PILs and writs. So ultimately, before going, I have to tell you something about what is the way forward for our clinicians and the AHA office bearers also. I mean, we cannot be just discussing it and not deciding on what we can do as a way forward. So for that, I need to show you one video. If it is possible for the organizers to start the video. End of life care, dignity of a human being, and practice
the problems related to it are faced by the hospital, patient, and hospital administrator is a very complex problem. Courts and judges, as well as lawmakers, have to some extent tried to find a solution to the problem. But I find that many of these solutions are impractical, sometimes impossible, and significantly short in terms of addressing the actual real problem that we face in hospitals in our day-to-day life. And why has that happened? The reason, according to me, is that we collectively as healthcare providers have not been able to tell the exact pain points that we all face while doing our day-to-day practice or our day-to-day administrative work as far as healthcare delivery is concerned. I am Dr. Nikhil Dakar. I am a gynecologist and I also happen to be the professor at the Maharashtra National Law University where I teach health law to the lawyers. In the past, my case, Nikhil Dakar versus Union of India, and the whole Termination of Pregnancy Act related activism has paved way to the amendment for the Medical Termination of Pregnancy Act, and many of you must be aware of my work. This was possible only because of making the judges actually understand the ground level realities that women and doctors face in their day-to-day practice, and automatically the solution came after some period of time. Now, coming back to the end of life care, I feel that the solution can be found. A solution which is manageable, practical, implementable at the time, giving required protection to the hospitals, doctors, and healthcare providers can be very easily found. This can be only done if at all we all come together and make the judges and the lawmakers understand exactly the pain points that we have. So how can this be done? This can be very easily done if at all a research project is created whereby hospitals join hand with me, with the Maharashtra National Law University. And this research, which is done by the lawyers for the purpose of the university, can be sent to the various authorities, and such kinds of things can further be followed up by various petitions on human rights grounds. I, being an activist, is a very passionate person in terms of end of life care, and is most willing to undertake such kinds of research projects. But what I want is support, help from people like you, clinicians as well as healthcare administrators. So it is my earnest request that if we can come together and join hands, it is quite easily possible to create such kind of a project. And by far and large, this work is going to be done in a pro bono manner. So it is my request that let us come together, let us try and find out a solution for end of life care, which is very dignified for the common person, for you and me, for everybody in the society. But at the same time, it provides a truthful, genuine protection to the clinicians, to the healthcare providers, to the administrators, and to the hospitals when they are administering end of life care to genuinely required patients who are truthfully in need to maintain the dignity of human life. Thank you.
So this was my friend, Dr. Nikhil Dakar. He was the one who, because of him, we got this new MTP Act where now we are allowed to even perform MTP after 24 weeks, and beyond 24 weeks also with proper indications. So there I have my last slide. Okay. Okay. So so just to conclude, what I feel is we have to flood the High Court with cases requesting passive euthanasia as per the guidelines of Aruna Shanbag case, because we cannot be doing jugards every day. Instead of doing jugards every day you make an application to the High Court. So let the High Court be flooded with all these cases. The way we flooded the High Court with the MTP cases, those cases more than 20 weeks, we flooded the High Courts with these cases, and ultimately wo judges कंटाल गए. अरे ये क्या रोज का ये cases आ रहा है? So they will eventually be will understand the importance of this particular aspect. Let's flood the Supreme Court with writs and PILs. Let's make this litigation free of charge for the patients. I mean, this is what we did for the MTP cases. It was free of charge for the MTP patients and the relatives. Let's find lawyers who are ready to take it up either free of cost or at a low cost. Let's convince our lawmakers to wake up to this genuine problem of the society, and let's join hands with activists like Nikhil. I'm not saying just Nikhil, but there are many activists like Nikhil. Let's join hands with them, because I feel that, again, slide. I mean, that was the last slide. I feel that if Nikhil can alone do it and make a difference for the MTP Act, then we can collectively make a difference when it comes to an end. Thank you very much for taking this. I'm ready to take questions. So then start. Out of time. Yes. The only answer I can give is sugar.
It is less of a
Yeah.
figure and the organization. And how you have become first. So end of life care, as sir has brought out, is a very sensitive topic for one of the country, the social aspect is facing. And towards this, a bill by the government of India, the parliament, end of life care bill was proposed in the year 2016. A law is yet to be enacted, as you know, the activists like Dr. Nikhil is there for that. What I like to bring out to the audience that on one hand, the government is yet to pass a bill. On the other hand, some of the hospitals, rather most of the accreditation agencies, mandate it for the hospitals to have end of life care policy. Example, the NQAS, and I'm sure for others also. So in that case, what we do? So what we can do is, like the Crux sir has brought out, there are various guidelines. Like AIDS has released a paper in February 2022 this year, and it was an extensive research where they have identified through a root cause analysis what were the causes which hamper the correct end of life care, and then what should be the end of life care procedure. At the end of the day, a physician's role is not just the duty to provide patient care or the healing, but also to not initiate or discontinue the procedures which are futile and not beneficial to the improving of life or the improving of that illness. And just like dignified life, the right to life, Article 21, a dignified death is also an important factor, sir. And towards that, the patient has to die in peace. And for that, the hospital policies, the ULC policies, have to be formulated till such time law comes, considering the peace factors. Now, this peace is different. Considering the factors as the physical, emotional, ethical, social, and spiritual needs. Thank you.
This is what many of the associations and many of the hospitals are doing. We doctors have done our duty already. Thank you very much for bringing on that. We have done our duty. Now the duty has to be. We cannot be doing everything that you are trying to do for the patient and get caught. Then the lawmakers and the judiciary have to take up the thing. Enough of data,
Start waking up and look for a proper legal process.
Exactly. And the required to work so long as the relative is not most of the time they are, because they are financially great. And we could contain it. But many times this has happened that एक relative आपको बोलता है because that relative is from Pune, he says बंद करो, and they try to impose the standards of USA on you, and they would say that you continue with it. That becomes a problem, and there is doctor.
When you are hanging on the tree, nobody is down there.
Yeah.
Because you take the phone care.
Right. Thank you very much. I have already got it.
Hello. Hello. Am I audible? I think I'm audible. Good evening, ladies and gentlemen. This is a very memorable seminar for me because I was not supposed to be a speaker in the panel discussion, and I got pulled in by the moderator, and I was not supposed to speak on this topic. But Dr. Machwe texted us that he is involved in some serious domestic emergency, and he has apologized profusely, because of which I have put together this presentation last night. Okay, so I was awake beyond Cinderella timings, putting up this. Fortunately, I've just completed a full module on legal and ethical issues for an institute in Hyderabad. So I also begin with a disclaimer, like the previous speaker, that I am not an expert on this, but I'll try to do my best because I don't like to disappoint the delegates and the attendees. Okay, so let's see what we can do. So although the topic says MTP Act 2021, I always feel that unless you know the history, you cannot know the present and you cannot design the future. So thoda pata hona chahiye. We'll start with MTP Act 1971, but before that you should know, because your generation probably is not even interested in what happened in 1861 or 1850. Okay. So you should know that in 1861, the pregnancy termination or abortion was illegal in India. It was illegal. Okay, no abortion was permitted. So that might come as a surprise to you. I thought I'll share this tidbit. Then the MTP Act was first passed in 1971 to permit abortions to be carried out legally, because illegal abortion clinics were ending the life of many women. Ladies were dying. In 1994, this amazing Prenatal Diagnostic Techniques Regulation and Prevention of Misuse Act came in. We'll discuss that also later. This is a timeline. In 2002, the word preconception was added to it because genetic labs opened in India. And the MTP Amendment Act has been promulgated in 2002. In 2003, MTP rules came up, and in 2020, the Medical Termination of Pregnancy Bill was passed. So you should know that first there are discussions, a draft bill is prepared, it is sent to experts, and then the bill becomes an act. So the bill was passed in 2020, and the act was then promulgated in 2021. So what does 1971 MTP Act say? Because many of the basic tenets have not changed. Okay. So this act provided for the termination of certain pregnancies by registered medical practitioners and for matters connected therewith. Okay. So this I've already told you. The entire country accepted this MTP Act 1971, except the state of Jammu and Kashmir, because of the religion does not permit. There are, just like we heard about the practice of Santhara by Jains. Similarly, because of that reason, in J&K, this act was never accepted. Okay. In 1971 Act, the pregnancy of only up to 12 weeks could be terminated by and upon an opinion of an RMP. Up to 20 weeks could be terminated upon the opinion of not less than 2. At least doctors should concur that MTP is required for whatever reason, usually medical reason of the mother, or if on ultrasound some serious congenital abnormality has been detected. It could be performed when continuation of pregnancy is gives a risk to the woman or cause grave injury to her physical or mental health, like she's got severe hypertension. She will not be able to carry the pregnancy to term or something like that. Or she has a previous injury to the uterus and there is a chance of the uterine dehiscence taking place, killing the woman. All that kind of thing has to be written down. It has to be recorded. Or there is a substantial risk to the child. So as long as you understand this, that MTP is performed either to safeguard the life or the health of the mother, or in cases where the fetus is considered either not viable, कि वो survive ही नहीं करेगा, or the baby has so many abnormalities that the baby's life will not be normal at all. Okay, so those have to be defined. when pregnancy is caused due to rape, MTP is permitted. When pregnancy is caused due to failure of contraceptive, this is the thing used most commonly by married couples, because what happens behind closed doors, whatever they give history, that history has to be taken as true by the doctor. So this is the commonest reason given by couples when there is an unplanned conception. Either the husband is not ready, or the wife is not ready, or they are whatever. So they just give this reason, failure of contraception. But it is legally permitted to do MTP if you say that this has happened because of contraceptive failure. It has been amended in 2002, where a district level committee is empowered to approve or reject a private claims for MTP services, because clinics started coming up, maternity homes started coming up. The word lunatic was there because if the mother is not in full possession of her senses, then MTP decision can be taken by somebody other than the woman. So that word lunatic was considered very offensive, because replaced by mentally ill person. And stricter penalties were introduced for dubious MTP to save the life of the women, because women were dying because of sepsis after unhygienic abortions carried out in unauthorized places by ill-qualified or unqualified doctors who were calling themselves doctors, but they were not really doctors. Okay. So now what happened in the year 2016 and 18 was that the Supreme Court, as I was saying, if no one is hearing, you have to shout. So many cases of women who were deserving of MTP beyond 12 weeks came up to the Supreme Court, that the Supreme Court favored relaxing the abortion deadline, and there was a consensus that there is a need to change the law, because before this, above 20 weeks, you could not do MTP for whatever reason. I mean, God forbid, the woman has not come forward for ultrasound at all. She's living in some remote area. Uska pehla ultrasound hi 22 weeks pe hua hai. At that time, if fetal abnormalities have been detected, everyone knows. The poor doctor also knows, the patient also knows, husband also knows, everyone knows. But because it is 22 weeks, no MTP allowed. So who's going to bear the burden of that child's bringing up? So because of that, this was a top-down directive by the Supreme Court that it is time for us to relax the upper age limit. In the world, the situation is different. And those of you who are watching BBC, CNN, or on social media or on TV would know that American public is divided completely on this issue of abortion. They are not even talking about 20 weeks or 24 weeks. They are talking yes and no, black and white. Okay. So worldwide, there are very strong and very fragmented opinions about abortion per se. And as usual, religion comes into it, activists come into it. The activists, they are equally vocal and equally powerful. There is a group of activists which is screaming and shouting. They are called pro-life activists. That the woman conception is there. It's a living thing. It's a life. We can't allow that life to be destroyed. They say that instead of abortion, an unwanted pregnancy, even after rape, they say that the lady or the girl, or even if she's minor, should be counseled and supported, allowed to take the pregnancy to term. And once she gives birth, it is the community which will come in and show that the baby is adopted. What's the problem? You see how opinions differ? And those, of course, who are in favor of abortion are equally vocal. They keep screaming that who are you to decide? How is the community the owner of my body? How is any religious group the owner of my body? How can you decide? It is my body. I am likely to die giving birth to this baby. And you are just promising tomorrow I deliver the baby. Nobody comes forward to adopt the baby. Who's going to bring up the baby? And what about my mental trauma? While I'm carrying the baby, I've developed an attachment to the baby. I don't want to give away the baby for adoption, but I'm just a high school student. I don't have the money. And with rape, there is so much hatred that the hatred is getting transmitted to the baby. So when you are hating something that you are carrying in your womb for 9 months, how happy will you be for bringing up that baby, which is the product of rape? So it's a very, very contentious subject, and worldwide opinions differ very strongly. So the MTP Amendment Act of 2021 was promulgated on 25th March 2021. And this is from Ministry of Law and Justice. Those of you who are interested in legal matters, you should know that many of the legal provisions which are applicable to healthcare are to be found in the Ministry of Law and Justice. Some are to be found in Ministry of Health and Family Welfare. Okay. So don't look in only one place. And now, thanks to Google, Auntie, you can do the Google search. Hopefully you will be guided. So this is just the timeline. I don't think we waste time on this. So the strength of this MTP Act are that it amends the Act to increase the upper limit for termination from 20 to 24 weeks. And the upper limit can be extended on recommendation of a medical board. Okay. And these are the differences. MTP Act 1971 and 2021. Up to 12 weeks, one doctor, 12 to 20 weeks, opinion of two doctors. Here they have reduced it. Up to 20 weeks, only one doctor. 20 to 24 weeks, not allowed. 20 to 24 weeks now allowed. Two doctors of the same category. It should not be that, you get one radiologist and one gynecologist, not like that. So both should be gynecologists. And more than 24 weeks was not allowed in 71. But here, interestingly, that even beyond 24 weeks, a medical board can be constituted in case of substantial fetal anomalies. Okay. It is, however, silent on terminating pregnancies due to rape that have crossed the 24-week limit. Just 3 days ago, I got a WhatsApp question. I'm an unpaid honorary consultant to a lot of friends all over. And it's a line, yes, the patient is in OPD. SOS. 16-year-old young girl, obviously a minor. Pregnancy 24 weeks. Brought to the hospital for MTP. Consent form के ऊपर अंगूठा लगा हुआ है उसके illiterate father का. And the girl is refusing. She says it's a love child. I'm not going to give consent. So I was being asked, patient is in OPD, क्या करें? 16-year-old girl, क्या करेंगे? Anybody? 16-year-old girl at 24 weeks pregnancy, not detected because nobody imagined that she is carrying a baby. They thought moti ho rahi hai laddu kha karke. Now she's saying, she's accepting. She says it's consensual sex. It's my love child. I'm not going to abort this baby. So that guy is saying, what am I going to do? He's a medical superintendent of a hospital in some state. What should be done? It's a medical legal case. A 16-year-old girl, she's pregnant. The pregnancy cannot happen by anything other than rape, even if she says it is consensual, because she cannot give consent. She is not of age to give consent. But can you go ahead with MTP? No, because it is her body. Right? She has a right over her body. Father or mother or guardian cannot force her to have an MTP. It should be absolutely crystal clear to you, even if she is a minor. It is her body. We just heard below 12 years, informed consent is not valid. That means above 12 years, informed consent is valid. If she's old enough to have sex with her boyfriend, she's old enough to give consent or decline consent for her MTP, right? So the correct procedure is admit, medical legal, and then call the medico-social worker for counseling of both the girl and the parents. या तो लड़की को समझा दो कि तुम कैसे पालोगी ये बच्चा, और या पेरेंट्स को समझा दो कि अब जब होना था हो गया, and it's 24 weeks, you don't really have time, right? And if this board, and that is the importance of this board also has social service coordinators, it has lawyers, it has a board of doctors, including gynecologists, okay, and psychiatrists. They sit down. First thing is the girl healthy enough or fit enough to carry the pregnancy to term? No, you can't say that. Of course, she's healthy. 16-year-old girls have given birth. It's not unheard of. So first thing is this. If that question is answered in no, then it is a no-brainer. It is a risk to her life. Then it becomes risk to the life. Whether the mother is 20 years or 16 years then becomes immaterial. Then the board opines that MTP is in the best interest of the patient. Then the patient has to be, again, the patient still has to be counseled. You still cannot do it without her consent. But if she is healthy enough to take the pregnancy to term, then the role of the social activist or whatever social worker comes in, can you then convince the parents to support the girl and help her and support her to carry the baby to term? I know it sounds like some utopian dream or something in India, how it will happen, but can the girl deliver the child and the child can then be put up for adoption? There are so many people. Long ago, I was asked on a surrogacy debate when the Surrogacy Act was not there, long ago, so 10 years ago, and I spoke against it. That so many orphans are there in this country. Adopt kar lo na unko. Why are you spending so much money and effort in surrogacy? So there are a lot of people who are willing to adopt a child. I'm telling you the way a situation can be handled, and it can never be handled unidirectionally by either a gynecologist or a administrator. You can't do that. You have to involve other segments of the society. It's a complicated term. But the time frame for the medical board decision is not there, because of which I believe a 10-year-old girl who was a rape victim about a year ago ended up taking the baby to term because the medical board was divided and they could not even give a decision. That is a no-brainer. Where it should have been kind of mandated, there they hesitated till the baby, they crossed that limit of safe termination. Neither termination is safe nor delivery is safe. That is tragic. Okay. And of course, the overall shortage of trained doctors. I'm keeping it short. PCPNDT Act pe aa jate hain. It is basically promulgated to save the girl child. It is enacted on 1994 and amended and implemented in 2003. Then it was again amended in 2011. Intent is to prohibit the prenatal diagnostic techniques for sex determination, because in India, unfortunately, and I believe it is common in some other countries also, we are not unique. It happens other places also. But here it became rampant that with ultrasound and all, or with other amniotic fluid testing, genetic testing and all, the sex of the baby used to be determined. And our whole nation is so mad for a boy child. The moment they used to come to know the sex of the fetus, MTP. Okay. And I told you, MTP ka biggest jugaad was, like sir was saying, jugaad reason, failure of contraception. Girl baby conceive ho gaya to failure of contraception. Boy baby conceive ho gaya to no failure of contraception. So we are selective, right? We are very selective. So in order to prevent this injustice with the unborn girl child, and then they define the prenatal diagnostic procedures, okay? And especially when there is a genetic lab or a genetic clinic, very detailed, I won't read them. And then the sex selection techniques, which are pre-fertilization, also post-fertilization, pre-transfer and post-implantation. So there are steps. There are steps in this, and the steps have been. Now, interesting thing for you all is that prenatal diagnostic testing is legal in some situations. So when is it legal for fetal causes? When there are chromosomal abnormalities suspected, when there are genetic metabolic diseases which have to be diagnosed before, hemoglobinopathies, sex-linked genetic diseases, congenital anomalies, or any other disease as may be specified by the Central Supervisory Board. There is a board also which has been put into place, because as I told you, either we do our job ethically or the legal authority will come and sit on our head. Maternal causes when prenatal diagnosis is legal. Age above 35 years, because after the age of 35 years, women, when they conceive, it is a statistically proven fact that the statistical chances of the chromosomal abnormality in the fetus are higher. That is a fact, physiological fact. The pregnant woman, if she has undergone 2 or more spontaneous abortions or fetal loss, has been exposed to potentially teratogenic agents such as some drugs, radiation, infection, or chemicals. The pregnant woman has a family history of mental retardation or physical deformities, as spasticity, especially those who are genetically transmitted. You have to prove that this particular illness is transmitted genetically or any other condition, right? And this is the huge regulatory body which is sitting on the head of hospital administrators and gynecologist or anybody who's running a genetic lab or a prenatal diagnostic center. Okay. So there is a policy making body, there is a central supervisory board, and there is a state supervisory board. And under that is a district authority, and there are two. No, there's an appropriate authority and there is an advisory committee. I won't bore you with the details, but just tell you, as I told you, that these committees, especially the advisory committee, have 3 medical experts, 1 legal expert, 1 officer, that is government appointed guy. and 3 eminent social workers. I just gave you the example that you have to have a 360-degree approach, especially when the pregnancy has crossed 12 weeks. Little bit higher risk beyond 12 weeks and even higher risk beyond 20 weeks, and 24 weeks ke baad to then you better walk on eggshells. Okay. Now we are a country of जुगाड़ in more than one ways, you know. अच्छे के लिए भी जुगाड़ करते हैं, पर मेरे ख्याल से बदमाशी के लिए ज्यादा जुगाड़ करते हैं. उस लोगों ने, this was conducted a survey in 2015. So this is what they found. कि female to male ratio गिरती चली जा रही है. There are no checks or inspections of these genetic labs. It's paper में है, but nobody is implementing it. Majority do not maintain the crucial documents as per PCPNDT Act. And no punishment. I mean, people are caught, the reporting is done, the complaint is found to be correct, but nobody is punished. And in this horrifying case of 2018, a doctor was arrested for conducting sex determination in the backseat of a car. Ultrasound hi to chahiye, sir. This I heard in Punjab also. I have done one stint in Punjab. Punjab is also notorious for female feticide. The 2 top states for female feticide are Tamil Nadu and Punjab. Okay, so Punjab में मारुति वैन बड़ी पॉपुलर हुआ करती थी, उसमें जगह होती है ना पीछे. तो मारुति वैन मॉडिफाई कर ली थी एक डॉक्टर साहब ने, और उसमें एक उन्होंने बेड सा लगा दिया था, काउच, एग्जामिनेशन काउच, और एक वो अपना पोर्टेबल अल्ट्रासाउंड लेकर के गांव-गांव जाते थे. सेक्स डिटर्मिनेशन करा लो, हाथ लगाते हैं जैसे आलू प्याज ले लो, he was like that. He's doing it. Okay, no punishment, but on paper any offense under this law is cognizable. That means a police officer can arrest such a defaulter doctor and the couple who are indulging in it without any warrant, and this offense is non-bailable. Getting bail is not the right of the accused. The courts have the discretion to grant bail. So I mean, in the morning you heard the advocate who was trying to give a lot of courage to the defaulter, saying कि घबराओ मत, non-bailable offense में भी bail मिल जाती है. But I mean, are we really wanting to go there as a society? That first you commit an offense which is non-bailable, then you look for a smart lawyer. We'll become like America. वहाँ पे है ambulance chasers खूब. They are called ambulance chasers. The such lawyers are called ambulance chasers. Patient को थोड़ी सी चोट लगती है, वो अपना business card लेकर के आ जाते हैं. In case you want millions of dollars as compensation, call me. I have got so many millions of dollars as compensation. हाँ, they publicize themselves. I have won 20 cases of medical negligences and total payout was in itne US dollars millions. They market themselves like that. It not an accident. Need a lawyer. Call Spencer. I've seen those billboards. Okay, I traveled to the US in 2002. And in 2002, I have seen those billboards. I was horrified. Such a culture shock to me. Okay, I've seen those billboards. And it is non-compoundable. That means in these kind of offenses which are related to PCPNDT Act, the parties cannot settle the case out of court. There is no out of court settlement. But the rider is that court cannot take cognizance of an offense unless the complaint is made by the appropriate authority or any person who has to give a notice of less than 15 days to appropriate authorities. And no court other than that of metropolitan magistrate or judicial magistrate first class shall try these offenses. So these are just 2 riders. Again, to ensure that, you know, doctors' dignity is protected. And these are the penalties. I still feel they are very low, but for whatever reason they are there. 3 years imprisonment and 10,000, then 5 years imprisonment and 50,000, then suspension of registration. First conviction may you remove the name from the register of MCI register. For second conviction, permanent removal. These penalties are there for violation of the PCPNDT Act. Person seeking to know the sex of the fetus, that means usually the father or mother, imprisonment 3 years or 50,000 fine. If repeated, 5 years and 1 lakh. Connected to advertisement. By the way, you're not supposed to advertise this, that you are conducting. So if there is an advertisement relating to this, again, and some miscellaneous offenses. This was the first case where a doctor and a technician were punished for sex determination. And the modus operandi became talked about. And ये इतनी पुरानी बात है कि उस दिन social media नहीं होता था, so I thought I'll probably share it here. The doctors have found ways to convey the sex of the baby to the parents without writing anything or without speaking anything, by the way. They don't speak anything also. So what they did in this case, modus operandi kya tha? If the doctor tells us to come and get the report on Monday, we know it's a boy, Friday means a girl. Then there were colored things, okay? So pen alag-alag color ke use karta tha. Ki signature in red ink to indicate a girl and blue for a boy. No words are exchanged. It's an unspoken thing and one doesn't even have to ask. Look at the greed of the doctor. Now see, he's keeping himself within legal boundaries. That's what I told you. That according to me, Dr. Patankar, I have very strong views on this. Ethics का जो ओहदा होता है ना, वो law से थोड़ा ऊपर होता है. Because they are getting away within the legal boundary, but they are still violating ethics. Okay? कैसे पकड़ोगे इन लोगों को? ये तो उसने statement दी. These are statements from the parents of the sex determination racket. That's how it came to know. Yeah, you break the technician and technician becomes state witness. वो बताएगा, technicians को सब पता होता है. जैसे OT में nurse होती है ना, उसको सब पता होता है. Which surgeon is good, which is bad, which causes bleeding, which causes more complications. They all know. The nurses know everything. Similarly, technicians know everything in this case. Okay? And if the doctor doesn't apply, some doubt does. Again, हमारी country, it's a country of middlemen. कि अगर डॉक्टर भी कुछ नहीं करता तो एक डाउट होते हैं जो सच्चे झूठे whatever, whether they are right or wrong, whether they are because unfortunately the couple, because of social pressures, are so desperate to know, and they want to know only for one reason. Why do they want to know? They only want to know for one reason, because if it is a female fetus, they will immediately go in for MTP. They won't call it feticide. We call it feticide. A legal person will call it feticide. They'll call it MTP. Okay, and then they'll get that surprise. Oh, it was a female baby. So both accused in this case were held guilty and convicted for the above offenses. So they were jailed also for 2 years and paid some fine, etc. Now we quickly come to surrogacy. This is a slightly longish thing, but again, surrogacy is still evolving. By the way, COVID has taught us an amazing lesson. Do you know that many babies born out of surrogacy for foreigners who had chosen surrogacy as the ultimate medical tourism option? Those babies were born during COVID time after lockdown and travel restrictions, and they were orphans. Do you know that? For 1 year, sir, किसी को पता नहीं था कि ये इन बच्चों को पालेगा. Because the mother, surrogate mother, has done her job, delivered the baby, just like Zomato delivers your food. She has been paid already in advance. And she has gone. वो तो गई अपने गाँव पर. Where does the baby go? The parents are in Australia or UK or whatever, and they can't travel. So they were called orphan babies of surrogacy. There is Mimi. Okay, I have yet to see that. Okay, thank you. So orphan babies of COVID born by surrogacy. So even though this surrogacy act is there, it doesn't cover that, because as per this act, surrogacy is not permitted for this act. The Indian act does not cover foreigners. So when the nursing home went begging to the government, अब जब तक पैसा मिल रहा था तब तक तो गवर्नमेंट की याद आई नहीं. जब वो ऑर्फन बेबीज को पालने का सवाल आया तो गवर्नमेंट की याद आई. Then they went running to the government. The government gave them a shut-up call that this act does not cover surrogacy for foreign nationals. So those babies are without a nation, without a law to protect them, without their biological mother, without their adoptive parents. So they had to be looked after by the nursing home or the institution where they were born. You understand now this responsibility that there will always be situations, and you have a long way to go. Okay, people like us have almost completed their active career as hospital administrators, but when you will grow in the specialty, you will find that whatever we big people and so-called experts are teaching you, will get defeated by the waves of time. Time is a very big teacher. COVID has taught us a lot of things. So 2021 में ये surrogacy act आया है, पर इसमें foreign nationals के babies का provision नहीं है. Okay, sure. They have defined what is surrogacy, what is a surrogacy clinic, what is a surrogacy procedure. Okay. So again, see, Indian infertile couple. This surrogacy act covers only Indian infertile couple. Doesn't cover single men and women. Okay. I don't know how Karan Johar got away with it and Sushmita Sen. And Karan Johar though falls in two categories. He's a single man and LGBTQ bhi hai. Sushmita Sen is a single woman, but I think unhone court ka darwaza hi khatkhataया. And they would have proven that they are financially stable and can provide a loving. Now Karan Johar stays with his mom. So he took his mom along. You know, the female part of the protection to the children will be provided by my mom. Okay. So again, if the woman is widowed or divorced, then the age limit has been set. And again, Indian origin couples. So no Australian and all are covered. Who is not eligible? This I think is discrimination against men. I really do feel that, you know, not fair. I mean, if the women can say that we can do everything, then man should also be able to. I don't believe in this. So in this, I totally have divergent views, but this is how the law is written right now. Single unmarried women, again, I think it's quite discriminatory. Couple in live-in relation. Amazingly, you know that couples in live-in relationships have been given almost the same rights as married couples. So then why not give them this right? What's the problem? So sometimes I tend to believe that old saying, you know, that the law is blind. Really, sometimes I feel that the law is blind. So this again is very funny. LGBTQ again, foreign couples, of course. Intending couple who already have a child, biologically or through adoption surrogacy, who's healthy. If they already have a healthy child, they cannot really opt for surrogacy. But if the child that they have has been born with some serious congenital defects or, you know, some mental issues, retardation issues, very low IQ or whatever, then they can opt for surrogacy. Who can be a surrogate mother? Again, everyone cannot opt to be a surrogate mother. Every married woman, this is not ever, every married woman. So that means an unmarried woman cannot be a surrogate mother. Age has been specified, should have had a child of her own. That means proven fertility. This is taking me back to already 18th century Victorian time where, you know, a woman had to prove her fertility before she was even chosen to be the bride. How they did that. Has a child of her own, willing woman, so no coercion. Should not provide her own gametes, only once in a lifetime. So one woman can be a surrogate mother once, but many, we know this is violated. There are women who have taken it up as a means of earning income, right? I don't know how they get around it. I don't want to go there. Okay, and they have to be medically fit. And कहने को ये कि altruistic purposes के लिए, जैसे पहले सारा organ donation भी altruistic purposes के लिए होता था ना, organ donation कभी कोई पैसे के लिए नहीं करता था, सब altruistic करते थे कि my heart is bleeding for this unknown stranger. Similarly, surrogacy में the surrogate mother is deemed to have a lot of, you know, milk of human kindness. All for money. Then again, certificate, some these are all, you know, medical indication ka hona chahiye. There's a lot of paperwork which goes into it, and if any gynecologist is opting to go into this surrogacy thing, they better know these formats are available online, so I won't go, and they must have insurance coverage for the amount and manner. Okay. Before starting the procedure, a special consent has to be obtained from the surrogate in the language which she understands. Informed consent, okay? And again, I told you altruistic surrogacy. पैसे का आदान प्रदान नहीं हुआ है. I don't know how. होता है वो, but it's not recorded anywhere. And commercial surrogacy means when there is a center which says that this is a surrogacy center. They are open about it. They do it for, like, the center has gynecologists and social workers and psychiatrists and whatever, what have you. They usually have a legal in-house counsel also. And they are upfront about it, that we are, going to do it on a commercial basis. Gestational surrogacy is when a gamete or fertilized embryo is implanted into the womb of the mother. Okay, so these are all semantics. You can read more about it. But what is allowed for the surrogate mother under the altruistic surrogacy arrangement? आप altruistic तो कह रहे हो, but what is allowed to be paid? That is the medical expenses, such other prescribed expenses incurred on the surrogate mother, and some insurance cover. Okay, so this is given to the surrogate mother or her dependents or her relatives. What is prohibited? No charges, no fee, no remuneration. If the gynecologist fees is there, if gynecologist expenses is there, so surrogate mother cannot be paid that. It has to be paid to the gynecologist. The surrogate mother cannot claim that. So she is kind of adopted by the couple for the duration of the pregnancy. Okay. So no remuneration. कहने को कोई remuneration नहीं, कोई expenses नहीं, कोई monetary incentive नहीं, and to surrogate mother or her dependents or her representative. So this, I think there are a lot of loopholes in this. I honestly feel, because whenever you say or, I mean, in a country where women are treated half the time like objects, what is to prevent a good for nothing unemployed husband to use his fertile wife as a source of income if he is being paid? Or kar diya na? Why not to the woman? Where is the or in it? She is the one who's carrying the baby. She is the one who is taking the risk. She is the one who is delivering the baby. Maybe they should have added to her dependents or representatives in case of her death. That sounds okay. क्यों अगर surrogate baby को जन्म देते समय मर जाए कहीं, तो उसके पैसे उसके dependents को मिलने चाहिए. That I think is a law of succession. But this sounds very wrong to me, that or karke they have left a lot of loopholes. And then the clinics have to be registered. The registration period is valid for 3 years, and registration certificate has to be displayed. Now, what if the surrogate mother changes her mind? She can only change her mind before the implantation of the embryo. Once the embryo is implanted in the womb, there is a written consent form that she has signed, and that consent form gets invoked. Once the implantation is done, then she can't back out and say that I don't want to carry this pregnancy to term. And again, same principles apply. During surrogacy also, if MTP has to be done, same principles apply like that of the natural pregnancy. That is all I'm going to say about it. Okay. And then embryo oocyte sperm freezing is prohibited. Import of embryos or gametes is completely prohibited, because I told you, it is only for Indian couples. So no import of embryos or gametes. Advertisements are completely prohibited. This again is a joke, I was grilled like anything during my online lecture, sir, by young students, because I told them that, doctors are not supposed to advertise their practice or themselves. I said, what, ma'am? What, ma'am? I said, yeah, because there is a code of medical ethics, which I taught them law and ethics. But ma'am, we see them everywhere. I said, yeah, because they are violating ethics. They are not yet violating the law. Now you see the difference. What is ethics and what is law? There is a code of medical ethics, which says that no doctor shall advertise himself or his practice. But same thing is for surrogacy. Advertisement is completely prohibited, but then how will they get the return on investment? No. How will they satisfy their investors? The surrogacy clinic will go bankrupt within a year if they don't advertise. So there is a total divergent view which the law has taken, the act, and what is there in the real world. In the real world, this is not possible. Surrogacy is an expensive business to set up and to run. It is a risky business. Again, the positivity rate is, even in best ones, it is 50 to 70%. Nowhere it is near 100%, right? So what are you doing? I mean, you are telling them not to advertise. How are they going to break even? There is a right to the child. This child is deemed to be the biological child of the couple who have chosen surrogacy and entitled to all rights and privileges of a natural child. Okay. It strictly prohibits abandonment of the child in India. I told you, na, COVID ne showed us the mirror. The child was abandoned. Children were abandoned, several of them, but not because of any fault of the parents, the couple who chose, because they were not allowed to fly out to India. Okay. Then there is a surrogacy registry in the country where you have to, send the details. Then there are surrogacy boards, and there are a lot of authorities involved in surrogacy procedures. I don't think we go there. So I think I'll finish quickly. I'll just conclude. This is the concluding slide. The MTP Act, PC-PNDT Act, and Surrogacy Act are all aimed at only two things: protecting the life and health of the mother and protecting the life and health of the child. It is as simple as that. If you understand that, you will understand the reason these acts have been promulgated. In India, the female fetus is especially at high risk of suicide due to social and cultural factors. In several communities, female child is not well. Poverty encourages commercial surrogacy because the woman is poor but she's fertile. She chooses becoming a surrogate mother again and again, renting the womb. She rents out her womb just because she can do it. She can have 10 children. So instead of having 10 children of her own, whom she cannot feed, she has one child of her own or two children of her own. Or her husband hears about the surrogacy or somebody family is breeding, and they put her in the surrogacy business. So then she goes ahead and वो एक के बाद एक दो साल के बाद surrogacy कर करके earning good amount of money for her family. She becomes the primary breadwinner. It's a tragedy, but it's the truth. Hence, even though they are there, including will become most effective only when there is a change in our society and in the way we perceive women. Otherwise, they will only remain something to be talked about in conferences and discussed. They won't have any teeth. कुछ कर नहीं सकते इन laws का आपका. Because people with bad intentions have already found ways to circumvent them, and only if the society changes its attitude towards the female fetus, towards women in general, and the doctors decide not to support illegal demands from the patients, whether the demands are accepted due to financial incentives, because if the doctor is honest, or sometimes the doctors are too kind. Their heart is also bleeding for the infertile couple. That's what they say. The financial incentive is never talked about. So there has to be a societal change. There has to be a change amongst the mindset and attitude and practices of the doctors. And till these two things happen, there is a law. Isme ulta ho gaya hai. The law has come before the society is ready to change. So let us hope the society changes. Thank you. Any questions? Any questions? I know we are running behind time, but if someone has got some question, which there's no point, Dr. Patankar, there's no point in denying, in case somebody wants asking. I mean, if you guys don't mind waiting a little longer, we can have other questions. Okay, no questions. Anyone from the back seat, if you are listening? Nobody's sleeping at least. No questions, all doubts cleared. Absolutely. But it's still going on. It's still going on. There is just a little caution now because of this Surrogacy Act. This is very new, sir? This act doesn't cover foreign nationals, sir? Foreign nationals तो उन्होंने उसमें cover ही नहीं किए हैं.
The court ruled that it was the responsibility of the institution that delivered, that it becomes like it happened in a corporate hospital. It is the responsibility of the hospital.
So you can't have your cake and eat it too. As long as the baby is a revenue source, you are happy delivering them. The moment they become a liability, you can't throw them in the dustbin, my dear. It was done like this only. The institute supported them. That I will also have to research. No special home will take it. The parents have not even signed up for them. I don't know how to explain it. That's what I'm saying. The surrogate mother has given birth to them. The surrogate couple has not come and signed the adoption papers. They're formally adopted. That's my understanding. There is a formal adoption procedure. But they are in Australia, na? They couldn't travel. No? They couldn't travel.
Right from the time, COVID is over now.
No, obviously. Yeah, that has happened. So they were temporary orphans. That has happened. They have. But there was a gap. There was a gap. It's not as if they have been permanently abandoned. I'm saying that COVID upset the calculation completely. So nobody was ready for that. Nobody was ready for that. Okay. Yeah. No, they can come. They can come. Who's saying they can't come? Medical tourism कैसे चलेगा? Surrogacy भी तो medical tourism के अंदर आ गई है. But they don't get protection of the Surrogacy Act.
No foreigner can come to India. Whatever surrogacy was done, this case that you are mentioning, was before the 25th of February. Now the Surrogacy Act has come. The rules have not yet come, but from the 25th of February to
2022,
this is enforced, which means now all this act has come because the foreigners would come to India and they would victimize all these surrogate mothers. For poor mothers with less amount of money, they would do that. So basically, the act has come to curb these policies. So now from the February of 25th, no foreigner can come to India and do a surrogacy. All those babies that you were mentioning will be handed over to the foreigners later on when they can come now. They must have come.
They've already done that.
They were temporarily.
So maybe this is an outcome of the huge problem which was faced with these COVID orphans. Maybe. I can only understand it that way.
From an Indian origin. An
Yeah.
Indian origin person may be someone who went from India, settled out in USA. He has an Indian origin. He may be an American at this point of time, but he is from an Indian origin. To read the act, surrogacy is allowed for somebody who is an Indian or from an Indian origin. So
Yeah.
he may be an Australian at the moment, but he has an Indian origin.
Yeah, they
can
say
come and do the surrogacy.
PIO, person of Indian origin. Yeah. That's
But a foreigner is not allowed. A foreigner can come to India and take ART treatment. A foreign couple can come here, and if you have an ART center, that center can give a treatment to the foreigner, wherein the foreigner is using his own sperm and her own oocyte. And she can become pregnant with an oocyte donor also. That's okay. But cannot do embryo transfer in a surrogate way. So that has to be very clear.
Thank you. Thank you. Yeah. It is not.
Madam, the word Jugaad is going to work here also. There will be many IVF centers who are running surrogate centers here in India, will now go to Nepal, will now go to Pakistan and have these centers there. And they will continue their practice. Madam, another
You
Jugaad.
have the answer.
Jugaad
See
shuru ho gaya.
what happens is that there is a surrogacy center with a big reputation in India. That entire surrogacy center will not lift up and block and go somewhere else. No, just taking the surrogate mother there, it sounds very silly to me. Once the implantation and all has been done, once she is in the 3rd or 4th month of pregnancy, if the foreign couple are ready to foot the bill, और अगर उनके पास इतने ही पैसे होते तो वो इंडिया में आते क्यों सरोगेसी कराने के लिए? You have not understood the mentality of the foreign nationals who come to India. I have several friends across the world, okay, doctors. So I see that they talk big, but when it comes to spending this much money also, no, they talk big. But when the question comes of money, तो एक डॉलर दांत से पकड़ते हैं. उससे ज्यादा तो जेनरोसिटी हमारे बॉम्बे के वहाँ एक कप चाय भी तुमको पिलाते हैं ना, कॉफी भी पिलाते हैं तो 10 बार एहसान जता देते हैं. So I have no, absolutely no, stars in my eyes about what a foreign couple is likely to do. You really think they are going to take her with them? Visa, travel, accommodation, social. You think they are ready to tell their white neighborhood that they have an Indian woman who is the surrogate mother of their child? Really? Think about that. They are also going in a community. They are also going in a community. Now with this act. अब तो होगा ही नहीं. अब तो होगा ही नहीं. Don't give ideas, okay, to people who are. Chal, I think we are running short of time. Thank you.
So now we come down to the last speaker of the day. We have the last seminar on legal and ethical challenges in emergency department by Dr. Ravi Pratap.
Speakers का यही है. Last but not the least.
Dr. Ravi is an MBBS, a diploma in emergency medical services. He also has a diploma in emergency medicine, a master's in emergency medicine, and a fellow in accident and emergency medicine. Currently working as head of Department of Emergency Medicine, Manipal Hospital, Kharadi, Pune, with an experience of 14 years working in and developing emergency departments of various multi-specialty hospitals, and has a special interest in forensic medicine and medical legal aspects of clinical practice. Over to you, sir. Okay, so can you do this? Now you can sit down. Oh, I can wait for this. Okay. So good evening, everyone. Thank you for saying that. Well, so legal and ethical challenges in the well, so I have been working in the evidence department, developing them, heading them, and a lot of other things related to the evidence department for quite some time now. And without going into very technical detail, it was such a thing. It was even for me, it was like, okay, something was that. So I keep it light, but whatever experience I have, whatever I have learned over the years is what I'm going to propose. So let us go ahead and see. So legal, medical legal for all doctors, or to the background of medicine. Is it really bigger than we think? Do we think here is but it is actually much bigger than what we think? Or is it something which is manageable, but we really think, oh my god, it's not bad. Is it so? What do you think? Something to wonder about, right? So knowing what exactly needs to be known is something we're thinking about. All right. So it is big enough to be careful about, but it is not that big that we need to be scared of. So that is what I would want to put forth here. Let's go ahead.
Okay. So what is so different about the emergency department? I'm talking about a separate lecture topic here. Believe me on this that legal and ethical challenges in the emergency department is something which can be taken as a separate webinar altogether. The whole day. But trying to kind of bring them together as small cases. Okay. So what is so different about the emergency department? Can anyone say here? Anybody tell me what is the difference from the other departments of the hospital and the emergency department? Yes, please. Okay. Okay. Thank you so much. Coming this from the administrators, I'm very glad. Believe me on this. I felt nobody understood us. Perfect. So this is what we do. Was worked in the same department which I'm from and now she's sitting for me, thankfully. So, and I have a colleague who still works there. So this is what it is. If you read the captions, it is something which, makes no sense. But this is what happens whenever it's a busy department. It is always like that. We don't make sense of what we are doing. It's chaotic and we find peace in our chaos. Giving an example of this, I used department years back, and probably it's in the city itself. This was during 2018, I believe. I'm not sure. 18? Yep. So this was the scenario on a daily basis. If you can count the number of ambulances with their doors open, patients on ventilators, BiPAPs, CPAPs, oxygen, waiting to be taken inside the emergency department. I remember in 1 month, we had admitted 1,416 patients from an 8-bedded emergency department. So it was mayhem. In this, ethical, legal, I have something which makes no sense at that time. But is there a way beyond that? Can we put jugaad everywhere? Let us see. Now, what I would like to say is, what is that instrument next to that? Dole. ये दोनों तरफ से बजता है. And हमारा department ऐसा ही है. We get hammered by the patient side, we get hammered by the hospital side. Why? Because हमने कुछ गलती की तो कहीं ना कहीं पकड़ में आता है. बाकी departments का पता नहीं चलता है. Right? So, let's go ahead. Case number 1. Okay. Again, delegate still joined with us. Can you move a little away from the podium? Voice audio go ahead. I don't know how it is happening. All right. Okay, I'll stay here. Sure. Okay. So, MLC, medico-legal case. Now, is there a specific definition for medico-legal case? What I have been told by experts, again, with disclaimer, again, I'm not a legal expert here, but what they say is every case, every patient is a medico-legal case. Potential, right? There is something called as injury reporting. Now, what we are supposed to do as doctors, what we are, bound by the law to be doing is informing any kind of an injury. There's a, there's an SOP of how and what needs to be reported. It is called as injury reporting. There is nothing called as medico-legal case as far as law goes. So injury reporting is something which from the emergency department we should be doing to the police, which generally is done, which you call MLC inform kiya kya. That's what is done, but it is injury reporting. Now, given this case, it's a 34-year-old female who presents with a fracture of her forehand. Okay, now you can see the X-ray, it's in front of you. She says she slipped and fell in the bathroom. Possible? Yes, very much. The husband is very anxious, seen apologizing to his wife. Why? Bathroom mein wo giri? Possibly. हमारे सामने दिखता है. When we are experienced in the department, seeing, reading emotions, reading faces, reading expressions becomes our second nature, right? So we know there's something going wrong there. Patient needs an admission and surgery, which has been told by the orthopedicians. The incident seems suspicious, right? Injury reporting has to be done to the local police, right? Everybody agrees? It's the end of the day. Please say something even I'm sleepy. Thank you. So, challenges. Patient and her husband requests not to file an injury report or an MLC, whatever we want to call it right now. Okay. Now what? Are we supposed to do that? We cannot. We cannot surpass that. We have to convince them that we have to inform to the police, irrespective. Now, what to mention in the mode of injury? She fell in the bathroom or the husband broke her hand? Now, here the patient is 37 years old, right? She's an adult, is in good sense. She can give consent and she can give the details of the incident. Whatever she says has to be documented as, again, as rightly said, it's alleged history of. We are not detectives. We are not the lawmakers. We are not the people who protect law. Yes, we can always mention what has been told to us as an alleged history, because whatever has been told to us, we have documented. Simple. We do not get into this, hum to rakshak hai, hum bacha lenge is aurat ko. No, not at all. That's not our job. Our job is give the right treatment, do the legal proceedings and go ahead. So what are the legal implications? If you have mentioned that, okay, the husband has pushed her, the lady is not telling you that. She might deny कि हमने कब बोला? I fell down. Then you are in trouble. तुम्हें किसने बताया? How can you write? मुझे लगा था ऐसा. That doesn't hold good. So go with whatever is being told to you by the patient. Death certification is another problem which we all, not problem, it's a day-to-day business that we take care of. A patient with Parkinson's, type 2 diabetes mellitus, and I've written twice. Anyways, sorry. He's an 82-year-old bedbound gentleman brought in by his son, found to be dead on arrival. It happens always, right? Brought in dead on arrival, whatever you want to call it. Patient is not registered with the hospital. Possible? Relative request for cash on delivery. See what's wrong with me. I think so. This is what happens. Whatever you see here, no? It's not cash on delivery. It's cause of death certificate. So sorry about that. So relatives request for a death certificate or a cause of death certificate, right? So what do? We'll give it, na? 82-year-old gentleman dead. क्यों उनको भेजना है पीएम के लिए? फिर आपको एमएलसी करना पड़ेगा, पुलिस आएगा, फिर बॉडी लेके जाएगा. Why do you want to do that? Now, first of all, please understand there's a difference between these: death certificate versus cause of death certificate. Death certification is something which any registered medical practitioner can do, where we say patient examined, no breathing efforts, no pulse noted, no cardiac activity. ECG, if done, can be written that asystole on ECG. Patient is certified as dead. Patient declared dead or patient certified dead. That does not mean that you know what has caused the death. It might be an 82-year-old man. And let me give you an example of this, how I got to understand the importance of the rule that is there, that you should not be certifying death if you do not know the patient. There was a patient who's used to stay in a old age home. This patient was, again, elderly gentleman with Parkinson's, dementia stuff. He was brought into the department, was declared dead on arrival. And because they requested, we thought, okay, fine, we'll give the cause of death as, whatever we want to. We can give something or the other. Luckily, what happened to the attendant who was there with the patient, there was a call that came and he gave me the phone. So I picked up the call. It was the family lawyer. This man who died had a property of 300 crores. And what he said, sir, have you seen this patient earlier? I said, no. Then I would request you not to give the cause of death. But there's a lot of litigation which is going on in his family. And in case if, it goes to court, you will be dragged to court for no reason. I said, okay, thank you for calling me. I am not giving the cause of death. So be cautious about when you give the cause of death. So be careful. And this is something where we have to follow the proceedings. So what are the proceedings in this case? call up the police. I mean, as register it as a brought in dead patient, hand over the body to the police. Whether the police wants to do an autopsy or not is beyond our prerogative. Okay, that is none of our business. We can always issue a certificate. We always give a letter to the dean of Sassoon that okay, we are sending this body for autopsy. Whether the police wants to take it or they want to do whatever but we have to hand over the body to the police. Now again, there is a jugaad here. We don't do anything. सीधा ससून लेके जाओ, हमें नहीं पता कुछ. People do that. We have seen that. कि हमारे पास तो रिकॉर्ड ही नहीं है. Patient आया, हाँ, patient is there, but you will have to go through with all these things. So it's better कि आप उठाओ और लेके जाओ ससून, वहीं पे कर लो जो करना है. It happens. Legally allowed? Definitely not. But then again, this is again a jugaad. Sir was using the term, so it caught up to me. Moral versus legal. Which one would you choose here? Morally, ठीक है, 82 years को क्यों? Why should we, put them through all these nonsense? Legally, you should be holding on to the legal side here. Options available, as I said, it is not something which should be done. So the only thing that goes here is, if you do not know the patient, you can always give them an option. कि अगर आपका कोई doctor है बाहर, who is a registered medical practitioner, who is ready to give you cause of death. Sometimes it happens, हाँ, मेरा doctor दे देगा. Prescription, patient is declared dead. This doesn't hold good. It has to be form 4 if it is in a hospital. It has to be form 4A if it is if it is out of hospital death. Okay. Now consent has been really taken well by the previous lecturers. So consent being another thing. Now giving you an example, a 19-year-old female presented with pain in abdomen and PV bleeding. Anyone practicing clinician here?
Patient previously, but now after some few months, he come dead upon arrival. So in that case, can you give cause of death to the patient?
Only if I'm confident that there is nothing wrong. There's no foul play attached. Sometimes it happens that patients are bedbound and the patient doesn't come to the hospital. The relatives keep a follow-up with the doctor. They bring the reports, they show them. It is advisable that if you know this patient and if you have the faith, can be given. The cause of death can be given. But if you have not seen the patient for 6 months and the patient has never turned up for a follow-up, you can absolutely deny cause of death. You can say, no, I've not seen this patient in the last few days, few weeks. I do not know what was wrong with him in the last 6 months. So you can definitely deny cause of death. Because see, I can give a cause of death, but am I ready to take that risk is the question. So if I'm ready to take the risk, I can give it. No problem whatsoever. But this is something which is as a, caution to be careful. Preliminary cause of death is given by the from the forensic department there at the government hospital. And in case if they want to preserve viscera or some kind of this, then the final report comes later. But the preliminary report is given immediately and the body is handed over. Sure. Yes.
I have a question. Sir, how frequently are doctors in court because of such issues? And maybe you knew the patient in that, if there is a patient, you knew the patient, he is registered in your hospital, you know his relatives as he was a frequent visitor or taking medications from there, and you gave the cause of death. But then afterwards, there was some fishy cause, and then the relatives have, the case has gone to the court, and then the doctor has been put to the court. In that scenario, what does the doctor do in this situation?
Doctors are not generally pulled to the court so easily. It was a one-off case, which I just took an example of. In case if you have given a cause of death, and if there is some kind of, foul play which has been filed by some relative, you might be called in. How did you come to the conclusion of this cause of death? If you say that the patient had an acute anterior wall myocardial infarction, what evidence do you have? You have not done an ECG and you have said that patient had an anterior wall MI. That is not the right thing to do. So you have to have evidence of what you're giving the death as. Now, if a patient who you have been seeing, he's in case of, dementia, Parkinson's, diabetes, cardiac disease, etc. It can happen. There's a sudden cardiac death, cardiac arrhythmias, dyselectrolytemia, whatever. Chronic cachexia is another cause that has been given by doctors. That is perfectly all right because you have records. this is the condition of the patient, this is how it has worsened, and then we have come to this conclusion. You have to be able to justify what you're writing. So there is no hard and fast rule that you cannot assert, give the cause of death. But if you're giving the cause of death, you should be aware that you should be able to defend it later in case, but not that doctors are dragged into court for certifying a death. So don't worry. Now coming to the next case, it's a 19-year-old female presented with pain in abdomen and PV bleeding. What will you think of? Okay, miscarriage and abortion. Anything else? Absolutely. Ectopic pregnancy would come first, right? Problem. Accompanied by the mother. She gives a history that LMP was 40 days back. And I missed to mention that this is an unmarried girl. You want to do an UPT? Of course, we would want to. Patient does not give history of sexual activity. So, is there a need for UPT? Mother is upset when we ask for consent for UPT. This happens very frequently, believe me. Mother is upset when we ask for UPT. Patient avoids talking much in front of the mother. Absolutely. So this is what is the first step to do. Send the mother out. We do that. It might be funny, but we do that. Hello, ma'am, please wait outside. This is the emergency department. We're not supposed to be inside. Get out. So she goes out. Then we ask, yes, bolo. So the thing is, can you do a UPT without telling the patient? It has to be again a written consent from the patient to do UPT. Now, once UPT is done, it is proven that the patient is pregnant. Now comes the ethical challenge. What do you do? This is a ruptured ectopic pregnancy. Patient is an impending crash. How do you explain this to the mother? Mother will be. Now that again, can we do that? The daughter is 19 years old. Exactly. Now the thing is, if going by legal terms, you can easily throw the mother out of the hospital if you want to. Take consent from the daughter, rush her to the OR, let the gynecologist take care of the ectopic, stabilize and discharge home. But then the question would come, who's going to pay the bill? It will be the parents ultimately. She's an unmarried girl and 19 years old. India mein bahut kam log kamate hain. So here the problem comes, but we have to be straightforward about telling what is the scenario. We have to tell her later, whatever happens, happens. We have to tell after, of course, asking the patient. Now legally, अगर कोई बाद में complain होता है कि नहीं डॉक्टर को मैंने मना किया था बोलने के लिए मेरे पेरेंट्स उसने बता दिया. अभी तक गया नहीं है इंडिया अभी वहां तक. But yes, it is a difficult situation and we do face it. Sometimes we have to tell कि ऐसा ऐसा है, प्रॉब्लम है कुछ पेट में, हम लोग अल्ट्रासाउंड करेंगे, गायनेकोलॉजिस्ट आके बात करेंगे. तो वी ट्राई टू गायनेकोलॉजिस्ट के हाथ में दे दो, हमारा हेडेक चला जाएगा. Now that is our जुगाड़, but that is not how it needs to be. See, legal point of view, the patient is an adult, can give consent for surgery and anything else for that matter, provided that she's not in hypovolemic shock and drowsy completely, not able to comprehend. Consent has to be taken for UPT. Consent has to be taken for surgery if need be. Explaining the situation is a challenge, but we have to find out some solution to how to be ahead. And then, if the patient's BP is on the lower side, it falls under the category of emergency care. It will be life-saving for this patient because within no time there will be a huge hemoperitoneum. Patient will die of hypovolemic shock. So there is no more time to be wasted. We can push this patient to OR provided everything else is within control. In Indian scenario, we have to be a little cautious about it. But yes, it falls under emergency category and intervention has to be done. Case number 4. Another problem in ER is communication. Now, patient is a 58-year-old male brought in ED with history of chest pain. ECG showed anterior wall STEMI. Okay, he's got a heart attack. Patient collapsed in the ED. By the time we could intervene and do something, CPR initiated, we intubated the patient, DC shock given, this, that, going on. Intubation done. Patient could not be revived after 30 minutes, 45 minutes of CPR and all ACLS guidelines and whatever you want to call it. Relatives are upset now. Once go and say, oh, your patient is dead. They get upset. They start alleging you that you have done incorrect treatment because patient came walking, complaining, talking. बात कर रहा था patient, ऐसे कैसे हो सकता है आधे घंटे का? What went wrong? Did anything go wrong here? You did the right thing. You intervened. Now, how many of you have given CPR ever? Quite a few of you. So whenever there is a crash and we are giving CPR and managing a patient, it is a time intensive, it is a labor intensive work that we do within a very short period of time. We don't have much time to spare. Now, in this situation, what happens? We generally forget what is happening beyond the curtain. Think about this. A person who's 58 years old, and today's era, 58 is not old. He was walking, talking, suddenly had chest pain, brought to the emergency department, he collapsed. But did you inform this to the patient's relatives? They are standing outside the door, like, what just happened? What is going on? They have no clue. Please understand. You have to explain what is going on. Now, what I personally do is always send somebody out कि patient के relative को बोलो या बुला के लेके आओ. In case if I am the team lead there and I'm intubating, I cannot leave the patient and go. So I always call the patient relative. So how to explain? You have to tell them truth, point blank. There is no time for नहीं आपका patient थोड़ा सा ऐसा हुआ था, अभी हार्ट अपन कर रहे हैं. No, be point blank. कि सर आपके patient को heart attack था massive. उसके बाद नहीं आया, patient का heart technically बंद हो गया है. हम लोग CPR देके we are trying to revive. शॉक भी देना है, मेडिकेशन देना है. आप प्लीज आके एक बार देख लीजिए, देन मैं आके वापस आपसे बात करूंगा. नाउ व्हाट हैपेंस? पेशेंट कम्स इन, ही सीज, इट माइट बी अ शॉक फॉर हिम कि व्हाट जस्ट हैपेंड, बट ही नोज दैट समथिंग हैज गॉन रॉन्ग एंड वी आर ट्राइंग टू intervene. It's not that we are standing by and letting the patient die. He's sent out again. Initial management has to be very extensive because we're securing the airway, getting the ECG defibrillation and this and that. Once the patient is a little bit kind of in sync, okay, now CPR is going on every 3 minutes, we are giving the adrenaline, then the team lead hand over somebody who's senior enough to manage the situation, walk out, give them a full brief of what has happened, explain them that we are trying our level best to get them. Don't give them hope, don't tell them nothing can be done. It has to be midway. We are trying our level best, we'll come back and again tell you. Now after 20 minutes of CPR, we almost know whether this patient is going to make it or not. Uske baad what we do is sama bandhna, right? In very crude language, sama bandhna zaruri rehta hai. If all of a sudden you go, हाँ ये आपका ECG flatline आएगा, patient मर गया, doesn't work. Doesn't work. You can get slapped, you can get beaten. So be careful about it. So you go out or train your team to go out, talk to the patient कि sir, अभी तक heart का rhythm नहीं आया है. We are still trying our level best. Maximum और हम लोग 10 से 15 मिनट कर सकते हैं. अगर उसमें आ जाता है heart का rhythm वापस तो it's good. If not, then we will not be able to do much about it. So then they'll be like, ऐसा कैसे, this, that. Answer a few questions. Then you go back. Show that concern that, oh, I need to be inside to take care of the patient. Come inside or wait for 10 minutes. See, after 20 minutes, generally the team lead walks out. चलो तुम लोग practice करो. No. Very sorry to say this, but this is what happens because we know we can't revive the patient. So what happens at that time? You should be very cautious. I'll tell you that later why. So then once the patient is declared dead, wait for the ECG to come as complete cases. Go and tell them, sir, I don't think he is able to make it. Last 5 minutes, he will still try, but I don't think that anything can be done. By that time, they start accepting there's something going. In case आपको आके देखना है तो आप चलिए. You bring that patient's relative together, show them what is going on, then again take them out and make them sit. And finally, when you get that ECG, which is a flat line, you can go and declare the death of the patient. Now, one thing, what should be seen on your face is concern and empathy. You cannot be, हाँ वो आया था अभी क्या. Now, language is another problem. There was a student of mine doing her MEM. She is doing very well right now, but what has happened? She was from South and she didn't know much of Hindi. Forget about Marathi. So she comes out. Tomorrow wo patient tha na, utaya. Literally, and I was like, oh, मैं गया. So I had to tell her, you can't declare like this, Baba. You have to be more empathetic. Sir, मैं क्या गलत बोला sir? मैं बोला गलत कुछ नहीं बोला, तेरा तरीका गलत था. So be careful about how you want to put it across. Next patient. 73-year-old male, known case of congestive cardiac failure in decompensated phase. That means his heart has absolutely failed now. Nothing much can be done. Multiple admissions in the last 2 months. So you know this patient is not going to make it now. Things are not looking very well. Brought in with severe breathlessness. NIV was put, but there's a failure of NIV. Needs intubation. Relatives request not to intubate. You know, if you don't, patient will crash. What to do? Are we? Patient is not in a state to give consent. That everybody agrees. Saturation 60% is delirious. So if the patient, we know this is again end of life. I need not go into the details. It was taken care of in the previous lecture very well. So end of life kind of patients where this patient cannot be salvaged. We have to take it in writing. DNI can be given by the close relative. We generally do not intubate such patient, maintain it on NIV, but be cautious about documentation. We have to document it properly, that it has been explained that outcome post intubation might not also be favorable. After informing every details of whatever the situation, patient's relative did not give consent for intubation. If it is,
Some auntie, uncle, or cousin or somebody is coming, and the actual son or daughter are furious.
Yes. Now this
And
is,
they take the
of
hospital.
course. Now this point, who is the attendant at that point? If it is the wife, then we need not go beyond that. So if it is son, see, now this again comes with, again, as Sir said, both have to be in the same thing. If they expect कि नहीं अभी तो इनको ठीक करके मैं हेलीकॉप्टर में घुमाने ले जाऊंगा, then we can't do that. But if we explain them properly, कि see, even if we intubate, it's not that कि हाँ इनको intubation की जरूरत है, intubate करना पड़ेगा, consent दे रहे हो क्या? It doesn't work like that. We have to talk to them for some time. That see, this patient requires intubation now. If we do not intubate, his oxygen saturation will drop. He will go into a cardiac arrest and might die. Now, if then we say, uska kya matlab hota hai? So intubation, they don't understand. You have to say, we have to put him on a ventilator. Once you use that term, relatives understand that situation is not looking good. Now, nahi ventilator pe nahi dalna hai. But then again, you have to tell them, you see, ventilator पे डालेंगे तो patient का भी life बच सकता है, नहीं डालेंगे तो he will definitely die. उसे डालने से ठीक हो जाएगा. Well, we can't guarantee that. Patient might not make it even after putting on ventilation. So we have to explain up to this level, provided that the patient gives us that much time. It happens कि हम discuss कर रहे हैं, patient crashes.
Worst case scenario is that some hired attendant, some nursing person, paramedic.
Yes. Then we do not wait for that. It happens.
So he is brought to hospital.
Yes.
The son is happily settled abroad. वो उल्टा टाइम चल रहा है.
Yes.
इधर दिन है तो उधर रात होगा. उसका फोन लगेगा नहीं लगेगा, साइलेंट पे है, ऑफ मोड पे है. So is it legally incumbent on the treating doctor to first wait for the actual son
No.
or daughter or wife to
No.
give the okay? Or
No.
just whoever is brought him, उसका बात मान के
No, not at all. This is where I'm saying who is the attendant does matter. Now, in this situation, what I have specifically mentioned, brought in by the son, not this one, the previous one, but this patient, supposedly if he's brought in by the son and the family is available there, we generally talk, and if they, and another thing which you should notice is multiple admission in last 2 months. So they are familiar with whatever is going on. Now, this is a very specific case I put through because we just happened to have a patient like this right now. So in this patient, if the son is abroad and if only an attendant has brought who is basically taking care of him at home, we cannot wait for the consent to come. We have to intubate this patient. The reason behind that is it is a life-saving procedure. To explain it to the relative ki why didn't we not intubate, ki अरे होना तो कुछ नहीं था तो क्यों intubate करने का? No. These are very specific cases. Please understand, do not generalize this. So you should not misinterpret what I'm trying to say. It's basically if the relative is there and is on the same page with you, which was in fact told to us just about 2 lectures back. If they are on the same page, okay, now we know they've accepted that nothing can be done. No, doctor, we would not want to intubate. Then yes, take it in writing, stop it there. But if the scenario which ma'am is saying, which is very common these days, son, daughter, everybody is abroad, fellow is brought in alone, staying with his attendant who cooks for him and takes care of him, obviously he is not a legal guardian to take any call for it. So at that point, we have to do everything till the time they decide whatever they want to do. So now it goes to ICU's hand, where DNE, DN, whatever they want to do. So at emergency level, we have to intubate this patient. So patient might die if not put on ventilation. Of course, can we withhold a life-saving procedure? I think I've answered that. And then the third point, documentation. It has to be foolproof. Now this one, power of documentation, I'll just tell you. It's a story time. Now, this is about 10 years back when I used to work in Chennai. It was the beginning of my night shift. And one patient had come with a laceration over his forehead, where the plastic surgeon was called in, was suturing it nicely. Another patient is wheeled in. History of explosion. He was a research scholar in a chemical lab, where he was doing some kind of an experiment with azide. I still remember it very vividly. Azide chemical. It's a chemical which is used in airbags. Sudden explosive nature without fumes. So it is used in airbags. So he was doing some kind of an experiment. The beaker exploded. All the glass shrapnels were on his face, body, arm. And this photo is not of that, but I managed to find one. One glass was embedded into the cornea. And this patient was exposed to azide as well. Azide as a chemical can cause seizure and metabolic acidosis. So that is a medical part. He had no symptoms whatsoever. So luckily the plastic surgeon was there. So I said, sir, can you please help me? So he, poor fellow, came. He removed all the glass shrapnels and sutured wherever it was required, did the dressing and everything. Then we saw the eye. I called up the ophthalmologist. Ma'am, XYZ patient has come. This is what the clinical finding is. Can you please suggest what can be done? She told, okay, you put this gel in the eye, just put a pad, close it. I'll see it tomorrow, because anyways, we're not going to do anything right now. So she asked me whether the turgidity is maintained in the eye or not. I said, I'm not quite sure. I'm scared to really move it because the shrapnel is really protruding out. She said, don't worry, just cover it. I'll come and see. Now this patient was admitted in the ICU for azide inhalation, not because of the physical injuries that he had. Now this patient was admitted in the ICU, then the ophthalmologist saw whatever happened, then discharged after 2 days of time. I have forgotten everything. After 6 months, the medical superintendent calls me. She says, Dr. Ravi, this is what, as a, summon has come, not summon, notice, a legal notice has come, that this patient has filed a complaint against our hospital, saying that he almost lost his eyesight. So he had to go to some other hospital where it was taken care of, but still partially he is not able to see. He has alleged that nobody took care of the eye. Now I remember this patient because this is a very rare case. Azide poisoning and such things do not happen every day. So obviously, and the hospital which I used to work with didn't have a electronic recording. So pulled out all the medical records thing, went through that. I opened the thing. I said, no, I have seen this patient. I have drawn a diagram. I still remember of the eye, where the laceration is, with an arrow, everything nicely written, informed so-and-so at so-and-so time, advice so-and-so, did so-and-so, done. Now, obviously, never ever had an experience of a legal notice so-called. I was scared. 10 years back, I was much younger than what I am now. So I was even more scared. So what happened? Then we had to go to the lawyer who used to take care of the legal matters of the hospital. So I go there, the lawyer, all, big shot lawyers, how you see in the movies, all books from here to there, and, fancy chair and everything with his white shirt and everything sitting there. He says, okay, this is the case. Okay, fine. Then he says, this lawyer is useless. I'll take care of him. Then he says, okay, show me the records. He pulls the records, he opens it up. Okay. Why did you make this eye? So obviously I had to make what the injury was. Okay, then he turns, ophthalmologist also written whatever needs to be done. He closes the thing, he returns back the file to us. You can go. You can go. I'll take care of it. So he already got the point that it has been seen and been taken care of. Now, how did he know that? Only one thing. Only and only documentation. If I had not mentioned that with the diagram and everything, probably we would have been in soup. So that is the importance of documentation. So what should be done in the emergency department or whatsoever in the hospital as a whole. Okay, as you, most of you are administrators, it's the hospital as a whole. Communicate, learn how to communicate, because that goes with all medical legal problems. If you do not communicate well, you are going to be in trouble someday or the other. Document. Third is document what you communicate what you document, and maintain the records. Make sense? Some important points. I'm not going to drag it any further. Now understand that emergency departments doesn't have walls. It has curtains. So what you speak inside the curtains can easily cross the curtains. We have landed in trouble. I have my colleague to actually say this. So what happens? Relative name is XYZ Singh. And if the lady was supposed to be wheeled into MRI or CT, I don't remember. Patient is really restless, not really, wanting to, comply for the MRI and all. So we were planning, okay, we'll call the anesthetist, sedate, and then do the thing. So this fellow, who's from Gujarat, doctor, says to another fellow who's also a Gujarati, in Gujarati, that give her a tight slap, she'll sleep anyways. In Gujarati. And the patient's son was standing there. The son is Singh, तो Singh को गुजराती क्या समझ में आता है? 2 दिन के बाद इतना बड़ा letter. He was born and brought up in Ahmedabad. So please be careful about what you or your team speaks. Here, being a chaotic, we speak whatever we want to. Sometimes we speak nonsense also. I admit to that. But be cautious that please make sure that curtain बंद है मतलब किसी को सुनाई नहीं पड़ रहा है, ऐसा नहीं होता है. Another very important point. An angry doctor is always trouble. That means if you get angry in a situation, your judgment gets clouded. And in a chaotic situation in the ER, if you lose your temper, it will create trouble some way or the other. You'll forget something, or you will either commit or omit something. Okay, coming to medical negligence, there are only two: act of commission, act of omission. So either you will omit something or you will commit something. So be cautious, don't lose your temper. If you are about to lose your temper, just walk out. Take a glass of water, calm down, come back. Because you can't run away from the department. And then, if a patient is shouting at you, if you think that this is going beyond your control, please walk out. You are not a security guard. You are not supposed to confront the patient relatives. Yes, logically, if a person is trying to ask you something, you have all the rights to talk to him. But when it becomes physical, please walk out. You are not supposed to get beaten up for no reason. You are way more precious than what otherwise people think you to be. So please make sure you do that. Because I've always advised my team, if there is a chaos, run if you need to. Don't get beaten up. Simple. No questions asked. उसके बाद जो होगा वो बाद में देखेंगे. मार खाने के बाद सोचने का कोई मीनिंग नहीं बनता. Thank you.
I request Dr. Subhash Sharma, head of the Administrator of the hospital, to present you with a memento. Thank you for such a clarifying talk, sir. I now turn to Dr. Rajendra Patankar, Regional Secretary of Academy of Hospital Administration, Regional Chapter, to deliver the vote of thanks.
I think a round of applause for Dr. Patankar.
ज़्यादा टाइम नहीं लूंगा, चाय और नाश्ता रेडी है।
रुक जाओ, आप इधर बैठो, आप बचा हुआ है। I think उसको भी
कोई बात नहीं।
क्या हो गया? That is too short. Yes.
My apology. My apologies. Dr. Rajendra is an MBBS and an MD in Hospital Administration and Planning. Currently the CEO of Jupiter Hospitals, Baner, Pune, commissioned and managed more than 7 hospitals successfully, with a significant role in brand repositioning of the iconic Nanavati Hospital, Mumbai. He is on the academic board of Dr. Valinkar School of Management for MHA course and Regional Secretary, AHA, Western Regional Chapter, Pune.
जगे हुए हैं।
Question पूछ रहे।
That was really good. I must appreciate that. Namaskar, good evening. Today I feel really honored and privileged to have been allowed to accept this vote of thanks. Happy to be hosting you at Jupiter Hospital at Pune. And for this enlightening series of talks that we had since morning 9:15. This is the first time after the COVID pandemic that AHA Western Region of Pune has organized an event. This is the first of its kind, and I'm sure many more will happen in due course of time. On behalf of Jupiter Hospital and AHA Western Region Center, I would like to thank all the honorable delegates, that means all of you, and those who have already left, and those who are also online, to be present in person and some of them online, to make this event a success. It's 6 o'clock almost now, and you're still here. Sizable, at least 75% of them are here, which means it is a success. And event of this dimension cannot happen overnight. The wheels started rolling months in advance, with Dr. Sulekha actually initiating the whole activity at AFMC's Department of Hospital Administration's office. We've been fortunate to have been backed by a team of very motivated and dedicated team of AHWRC and of course the Department of Hospital Admin, including Colonel Drs. Surekha Kashyap, Dr. Saroj Patnaik, Dr. Bhanu Pratap Singh, Dr. Ajay Ganguly, just to name a few. I cannot thank everyone enough for the involvement they have shown and the willingness they have expressed to take on the completion of tasks beyond their comfort zones. The scientific session was extremely impressive and quite long as well. But I'm sure people enjoyed. Of course, थोड़ी भूख लगी थी लेकिन इस time पे. But a big thank you to Dr. Karthik for his efforts towards enlightening us on the legal boundaries of healthcare in the Indian context. I must mention our deep sense of appreciation for Advocate Milind Saunke, who shared his real-life actual experiences, being a lawyer, of course, which will help us in understanding the medico-legal aspects in a much more deeper and a simplified manner. I extend a hearty vote of thanks to Dr. Panchuram Gokil, a very, very senior doyen in the healthcare in the city of Pune, who spared his time from his schedule to grace the occasion and shared his insights on the consents, the whole major issue of consents, which we always normally face. Grateful to Dr. Dilip Walke handling the post-prandial session and handling it very, very well. Dr. Kashyap, wonderful, really enjoyable session. I mean, we refreshed my memory of all the PCPND and MTP acts. And sometimes you need a refresher course and very, very pertinent points with good examples that you gave. Thank you so much for that. Dr. Mr. Vivek Padagaonkar, my colleague from the advisory board at the Valinkar School of Management, especially from Mumbai. This time we had planned to have speakers only from Pune, but as an exception, we called him and he gracefully honored us. I wholeheartedly thank all the panelists, including Group Captain Dr. Tilak, Colonel Dr. Saroj Patnaik, for the extremely insightful and interesting panel discussion. Of course, others were also involved. Special thanks to Dr. Ravi for handling the last session. it's not easy to be a last batsman or last bowler. It's always a tough time handling the last over, and you did that wonderfully well. I must appreciate a big round of applause for him as well. Special thanks to my friend Sanket Barale. He's not here, but his team helped us in handling the online coordination with Zoom. Thank you so much. His colleague Dipin was here some time back. Vikrant from IT team. My FNB team head Saroj and his entire crew of FNB. I'm sure you would have liked the food, and I'm sure you will like the snacks as well. Last but not the least, I want to extend a vote of thanks to our organizing team and the admin staff for making this event so wonderfully organized. Of course, there were a few glitches. I've made a list of points and I will correct it in the next session. I also cannot overlook the efforts of our volunteers, including Himani, Namrata, Harsh, Prashant, Sahil, and Anushruti, who gave their last week and worked dedicatedly for this conference. Thank you so much, all of you. Sincere thanks and specially thanks to Dr. Kushagra, Dr. Vasudev, Dr. Lavnish, and Dr. Akshay. Thank you, Dr. Akshay, from the Department of Hospital Admin, AFMC, for all their efforts. We hope to have more such enlightening and intellectual sessions. And a special thanks to my colleague, Dr. Chandramani. He has been behind this silently. Please raise your hand. Madam is calling you here. He's my colleague. He's a medical coordinator at Jupiter Hospital and the organizing secretary for this event. We're also conducting hospital rounds, holding hospital rounds in Jupiter Hospital for MBA and MHA students, MBHA as well, for budding hospital administrators, and so that they can gain some practical knowledge on various topics. I hope the worst of COVID is behind us now, and I can look forward to more such interactive sessions. We have a wonderful auditorium that you all see. Intent is to have a lot of such sessions for administrators as well, where we can do actual live rounds across the hospitals, and I think that would really help. I would also like to invite all the budding administrators to enroll with Academy of Hospital Administration. Those who are interested, just give your names at the reception at the registration desk, and we will coordinate with you along with WRC Center to get registered. A lot of interesting events what happen. You could be a part and parcel of attending and participating in them as well. So finally, time is money. Then today we have spent $1 million for us. You have spent $1 million for us. Thank you so much, and let's see you once again after some time. Thank you.
I want to give knowledge received in all of the speakers for the lecture talks. Grateful to the audience for their active participation and interest. I'd like to share a common feeling of Sage Nation, and yet I can't help but say, more. So till the next conference of Western Leadership Chapter, I wish this wonderful audience and our speakers a very good evening. Thank you. And we request the group of the organizers if they could stay back, and for the rest, please also again being organized. IT now is being organized in the same area to the right of the hall.
Dr. Chandramani, as usual, is searched. The chai. High tea. Energy expenditure. Thank you for joining in. ऑनलाइन वाले कनेक्टेड रहे हमारे से, डिस्पाइट द इंटरप्शन, मैंने टोल्ड देम
ये आना चाहिए मेरे ख्याल से, है ना, क्योंकि ये तो छुप जाएगा मेरे ख्याल से। आइए आइए।
आइए नम्रता। Thank you. Thank you so much.
ये शेयर कर देंगे फोटो, कभी घूम जाती मिलती नहीं।
हाँ बिल्कुल, अभी निकाल लो, एक फोन निकाल लो।
फोन लगाएंगे
तो अभी एचडी में आ
बेस्ट
जाएगा।
आइडिया है फोन।
Thank you. Thank you.
आज हम फिर कैसे अकोमोडेट कैसे हो गए? I know where you are from because I know your faculty.
Actually, we are classmates.
We did our MD together. We were a large batch, so 6 of us. I think reformation, social media, ज्ञान।
अरे किसी और को बोला
किसी और को बोला ना
फोटो
फोटो
करना।
खींचने के लिए। You come and join.
Actually, she's the part of Jupiter.
Yes, sir.
अच्छा। ओह। फिर मुझे लगा अब she works with अपने इंटर्न में से कोई है। Thank you. Thank you. Thank you. Okay. Okay.
So now, the 30 students.
Oh my goodness, very good. MBA help. 2-year course है ना?
2-year course now. And all of them are some graduate now.
सब MUHS के MBA कोर्स के स्टूडेंट्स हैं। तुम लोग कहाँ से आए थे?
Pune ma'am, they are within Pune. Oh ma'am, you did a quality workshop. Communication. Abhi again we start ma'am. The call.
So these are all very funny favorite subjects like communication, healthcare, quality, and all. You now understood both of it. That's why I insisted that
He has to be there. We take one good photograph with sir and ma'am. Can we take on just drop the link and we'll take one photograph. And I request one of the job opportunity from me.
हाँ, वो तो है ही है। Some of you can sit down here. Those who can kneel down should kneel down. Otherwise, बहुत मुश्किल हो जाएगा। वो तो किसी को बोलते हैं। Make sure that your faces are visible, okay? जो नीचे बैठ जाओ जिनको प्रॉब्लम हो रही है। छोटा सा sit down. Some people sit down. हाँ, वो एक और रो में आ सकते हैं।
चेयर देते हैं इतना समोर मतलब चेयर बाजू का लगता है ना आगे हाँ एक मिनट रुको साहिल आए क्या हाँ
हाँ